we have outlined in our statement the fact that South Africa is a participant and continues to honor its obligations under various international human rights and continental human rights instruments. But we further said that Africa is in the process of strengthening its own human rights institutions and instruments to which we are party under the auspices of the AU. And our commitment is to continue to work closely with like-minded countries at AU level to ensure that South Africa continues to be the beacon of light in the promotion of human rights here and elsewhere in the world. The question relating to whether this is a vote of no confidence against the ICC, let me indicate that South Africa, as one of the, I think, approximately 127 or so state parties to the Rome Statute, at its session in November last year in The Hague, was it The Hague or was it New York? I think it was The Hague. Yeah, I think it was The Hague. Sought assistance from the body politic of the ICC, which is the constituent members of the ICC, to clarify the apparent contradiction or confusion resulting from different interpretations of the relationship between Article 27 and 98. It was clear from the debate, and I participated in that debate, and we sought to outline our understanding of the obligations of the Assembly of State Parties, namely that under international law of interpretation, the body that establishes the international agreement has the final word when it comes to interpreting the meaning of that instrument. And based on that understanding of international law, we sought assistance from the ASP, Assembly of State Parties, to at least bring the uncertainty to rest by providing that interpretation. We were not successful in that campaign, if you like. Instead, we were generally referred to the judicial chamber, which we have difficulties with. We have certain issues that are still pending with them. We felt that they did not allow us to enjoy fully our rights under Article 97 when we sent an envoy back in June before President al-Bashir arrived here, seeking clarity on our obligations prior to his arrival, etc. I will not go into those details. I think, as I indicated, we will set out the full background of this drawn-out history between ourselves and the ICC relating to this matter. But essentially, at that meeting, the matter was referred to the Bureau of the ICC. We went to the Bureau, we made our representations based on our understanding of international law. Whilst there was some appreciation, at least from some of the members, it was clear that we were not going very far with this matter at the level of the ICC. And that is one of the considerations that led us to come to the conclusion that after a drawn-out effort to try and have this matter resolved where it belongs, we have not been successful. Of course, we have participated at the AU summit in January in Addis Ababa, where we again briefed the AU of our experience. And of course, we received support overwhelming support from the AU in this regard. So we are at a point where we have decided as a country that we do need to put this matter to rest. We need to move on as a country. We do have work to do. We need to promote peace, stability, and prosperity in Africa. And we cannot achieve this profound policy goals and our international policy for as long as we continue to be impeded by these legal impediments. And hence we are where we are.